Hey everyone, Harry here to talk about a really important development in the January 6th probe by Jack Smith. So the actual insurrection itself, which we know is way more complicated, way less developed, but in many ways the most serious, the most kind of characteristic of the wickedness and unprecedented anti-democratic ways of the former president. All right, and it is an order by the district court, so we're not totally at the end of the road, for Mark Meadows to testify. Not just Mark Meadows, by the way, it's 6 or 7 other people, but Meadows is really the big guy here. Let's review just a bit. He is Trump's main facilitator and definitely witness. Remember, during the time, everyone's going to him to try to change Trump's mind, but he's with Trump. He actually, the more we learn, the more we know he is orchestrating a lot of the Trump kind of pressure campaign involving members of Congress, or not even pressure campaign, kind of conspiracy. He is deeply involved in Georgia and all the attempts to interfere with the election that go on there. And come January 6th, he is just if anybody is by Trump's shoulder and has Trump's ears, it is Mark Meadows, who pretty much by a combination of fluke, luck, and excellent lawyering has been out of the fray. When the January 6th committee started to investigate, he at first cooperated and gave over some emails, the ones that he chose, that were themselves a treasure trove. And then he just stopped cooperating. And then they actually, remember, voted out contempt charges against him, which the department declined to go forward on. But during the whole time that the committee, the January 6th committee, was investigating, putting on evidence and the like, they had to take a hands-off posture with respect to Meadows because they were in litigation with him. So now comes Jack Smith, and one of the first things anyone would want to do, subpoena Mark Meadows, and Trump makes a claim on behalf of Mark Meadows and several others, just to name them quickly. We got John Radcliffe. We got Stephen Miller. Remember Stephen Miller? We got Dan Scavino, John McEntee, really big guys, but nothing like Mark Meadows, who is, I'd say, the biggest witness in the whole thing and maybe the second most culpable person. So Trump calls to quash the subpoena on the ground of executive privilege. They've been down this road before, have the D.C. District Court and the Court of Appeals. They've been down it with Pence's main people, his counsel and his chief of staff. They've been down it with 2 important lawyers, the White House counsel and his chief deputy, Pat Cipollone and Pat Philbin, in the White House counsel. And they've made clear that the executive privilege claim is lousy in several different ways. The first point of attack against it is Trump is not acting he is outside the outer perimeter, as you would say, as the courts would say, of the kind of conduct that gets one executive privilege. When somebody's literally, it's like the anti-executive privilege situation. He is fomenting, rebellion against the democratic norm of peaceful transfer of power. Even if he weren't, we have the current occupant of the White House, and that's the person to whom executive privilege is, who is the custodian of it. No single person owns it. It's the office of the presidency, and Biden has waived it. And then we have finally, and I think this just is the point that has to prevail no matter what the Supreme Court or other courts do with the other two lines of attack. There is, under the Richard Nixon case, a well-established, that was a unanimous rule that says executive privilege, which, by the way, was only invented by the courts and the Supreme Court in the last 50 years or so, is a qualified privilege. It has to give ground if there are other reasons and that are more compelling. And one of them is a need for evidence in a criminal case that you can't get any other way. So Jack Smith is going to be easily able to show this stuff that Meadows knows, and actually so much. There's just a wealth of things can't be, if they're able to successfully assert executive privilege, they just couldn't receive it, and that would be anathema to a more important value of the rule of law and the vindication of the criminal law. So after really being able to be on the sidelines for a long time, Mark Meadows, who to my mind is public enemy number two, in a way, it's an outrage. He's a public servant, and he's acting like a mobster, forcing people to come after him to get him to just tell the truth. This is the breakthrough moment. It happened about a week ago, just before Judge Beryl Howell left her post. That's now been assumed by a new chief judge of the D.C. District Court, Jeb Boasberg, but it's not. That gives no prospect of any kind of change. So Trump will try to appeal, but it's already been turned down by the D.C. Circuit. His only hope, and if nothing else for some delay, is to get the Supreme Court to try to recognize some executive privilege or right to assert, even when the current occupant has waived it. That is an interest that Justice Kavanaugh, among others, has shown. But if they're playing it straight, and there's a lot of reason to think the Supreme Court really doesn't want to be establishing important conservative legal principles that they want to establish in the context of Trump, who, among other things, has said, they've all betrayed him. But it would be a very good reason not to take the case that is going to come out the same way because of the Nixon principle. So even if it's arguably presented this notion of whether a former president has any ability to assert it, it's a bad case to take it up. Of course, on the other side of that is there aren't very many. So there's a scenario in which I think the Court of Appeals already has, in similar situations, upheld this kind of ruling. I don't see that changing. The question is, would the Supreme Court do anything, take the case, and the like? My best guess, no, but it's not one of those 90-10 guesses. It's more like one of those lawyerly 65-35. But in any event, a necessary first step, a huge first step, because now Meadows is thrust front and center. It does present the question, right? They would not have to worry about executive privilege is one thing. We can also expect Meadows to assert the Fifth Amendment, which he has done before. I guess not surprising. He's thinking about his own skin, but this is a public servant who really got involved with just presidential perfidy and is just, hunkering down like a mobster. Anyway, if he asserts the Fifth, which I expect he will on at least some topics, and that would be, again, only after the current. He's now been ordered to testify. He gets to take that through the appellate courts. If, assuming that is affirmed, then it comes to him to actually show up. If he then takes the Fifth, the Department of Justice will have to decide, do they want to give him immunity to force him to talk? Because if you have immunity, you can't say your answers would tend to incriminate you. Normally, the rule is somebody so high up and guilty, you don't give or offer immunity to. But everything about this case and this former president is unique and unprecedented. The other thing about giving, so that would be give immunity and make him talk, or prosecute him if they have enough. So the leverage here is not, well, you have to. It's rather, we're going to put your butt in jail for years if you don't start cooperating now. And that would be a kind of, who will blink first contest. So we are far from getting the whole skinny from Mark Meadows, but we are much closer than we knew we were just a week ago. And he is, to my mind, the single most important witness out there as far as January 6th is concerned. So lots to follow here and really important stuff to follow. I will be all over it, you can be sure. And so you can be sure that I'll be back. And until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.